right, you guys. I think we're almost there. I don't know. The computer's being really dumb. So I don't guarantee anything. But I think we're back. We'll see. We'll see. We'll see. We'll see. I hope we have sound this time. I'm showing sound on the computer. Can hear you? Can you hear me, Sheila? I didn't do a darn thing but reboot everything. Can hear you. Yes? Yes, yes. Are we on? I have sound. We have sound. Score. Touchdown. All right, you guys. All right, already. So let's just start all over. Let me go back up to page 1 here. And this is a petition for a review for the Supreme Court by Zellner. So I'm really excited. Hey, Julie Lovely. Sheila Smokey's with me and Nan's Life, of course. All right, lovely ladies. There's a gentleman in the house. Michael J., great to see you. Okay, you guys. So this is a review. It was put out yesterday. I'm not sure public had access or not yesterday. I actually had to work like 12 or 13 hours today. So I wasn't able to get on here and read it till now, but I'm excited to do it with you. My voice is a little hoarse. We've been doing some serious renovation of an older house, and I swear to you, it's not the best, healthiest thing. Yes, I'm wearing a mask, but it still leaves you like this, so. Okay, I'm very excited to be here with you and to get into this. Now, this is a cold read, so I'll probably stumble over a few things, but it is what it is. Oh, yeah, you hear that? I have a severe thunderstorm coming in, too. So if for some reason I just drop off the live like snap, I may have lost power. We just got done with a hellish storm. Yeah, yesterday morning? Or no, the day before. Okay, you guys, who's ready for this? I'm ready. I have no idea what this is all going to entail, but I assure you it was well thought out. In the Supreme Court of the state of Wisconsin, this is State of Wisconsin versus Steve A. Avery. You're going to enjoy. I'm excited, Nan's Life. I'm excited. All right. This is, of course, Kathleen T. Zellner and Stephen G. Richards. Let's jump to page 7. And I know I can just go over there and type it in, but it takes forever to load because I'm live. Issues presented for review. Number 1. I'm excited. Here we go. Whether the Court of Appeals imposition of a pleading standard requiring Mr. Avery to prove on the face of his 974.06 motion that each allegation would result in an acquittal conflicts with controlling opinions of the United States Supreme Court, this court and other Wisconsin Court of Appeals decisions, the trial court held no. The Court of Appeals held the trial court did not err in denying the post-conviction motion without an evidentiary hearing on the matter. Number 2. Whether suppressing and withholding a CD for 12 years containing a forensic police report of allegedly impeaching and or exculpatory material requires an evidentiary hearing to determine if a Brady violation has occurred. The trial court held no. The Court of Appeals held the trial court did not err in denying the post-conviction motion without an evidentiary hearing on the matter. Number 3, whether a state actor's destruction of contested evidence in violation of Wisconsin Statute 968.205 is sufficient evidence of bad faith to require an evidentiary hearing on a Youngblood versus Arizona claim that the destruction of evidence violated. No audio. Are you serious? Can you guys hear me? I hope I didn't lose audio again. Somebody give me a yes or no, please. Sound check. Testing. 1, 2, 3. Oh, that's not good. This is not meant to be shared by me tonight. Okay, we rolling. Sorry, Merc. Sorry, love. You're going to have to go back in and try to come back in again. I guess we did have audio problems. It was us. We restarted a live. We have sound now. He's not hearing me. Why am I talking? This is what I'm talking about. I'm tired. I'm telling the guy why he can't hear me. Good God. Will one of you please let him know to come back in? Thank you. Okay, number 3. Whether a state actor's destruction of contested evidence in violation of Wisconsin Statute 968.205 is sufficient evidence of bad faith to require an evidentiary hearing on a Youngblood versus Arizona claim that the destruction of evidence violated a defendant's right to due process of law. The trial court held no. The Court of Appeals did not address Mr. Avery's Wisconsin Statute 968.205 claim. Now, that's a big one for me, but we'll see. We'll see. I'm not a lawyer, and I don't play one on TV. Okay. Oh, listen, somebody's revving their truck. I'm sorry, y'all. If you rev your truck all the time, it's like you're screaming out, listen to me, I'm wanting attention. That's just how I feel. Okay. Criteria for granting review. We're on page 8 if you're following along. The primary function of the Wisconsin Supreme Court, quote, and I quote, is that of law defining and law development. Cook versus Cook. Misters, oh Lord, you guys, this is going to be good. Mr. Avery's case has produced an avalanche of coverage on a worldwide stage. It has generated legal commentary that has not been matched in the last 50 years. I'm savoring this, you guys. This is magical. Law review articles, law school classes, class law, petitions to the White House, and millions of documentary viewers have grappled with one fundamental question. Did Mr. Avery receive a fair trial free of constitutional violations? When Mr. Avery was indigent and unknown, the Wisconsin courts dismissed his 2013 post-conviction motion as lacking any merit and being based on, quote, wait a minute, we're already in a quote. We're going to double quote. Unsubstantiated claims, empty and without substance, wildly speculative, and contrary to Wisconsin's long-standing law and procedures. Now that Mr. Avery has obtained post-conviction counsel and nationally renowned experts, the Court of Appeals has applied a great enhanced pleading standard to his 974.06 motion and has failed to look at the cumulative effect of the ineffective assistance of counsel in Brady versus Maryland claims. Can someone help him, please? I'm back. Is she talking? Anyone? Oh, boy. I'm so sorry, Mercury Con. Tell him I'm sorry, you guys. Please tell him. Now, Mr. Avery has obtained post-conviction counsel and nationally renowned experts. I almost said re-owned. Lord. The Court of Appeals has applied a greatly enhanced pleading standard to his 974.06 motion and has failed to look at the cumulative effect of the ineffective assistance of counsel in Brady versus Maryland claims. Also, the Court of Appeals has made significant factual errors resulting in unreasonable application of the facts in its analysis of the bullet and bone evidence, which, among other errors, results in its erroneous exercise of discretion in affirming the Circuit Court's denial of an evidentiary hearing. Mr. Avery should not be held to a higher standard than other movants. This court should apply the standards it has so clearly articulated in past cases and allow Mr. Avery to have an evidentiary hearing on the merits of his allegations of constitutional violations. If his conviction truly has integrity, it will withstand the scrutiny of an evidentiary hearing. Without such scrutiny, the question of integrity and fairness of Mr. Avery's trial hangs like a dark cloud over the Wisconsin judicial system. Mouth on the floor. Wow. We have to read that again. Okay. Without such scrutiny, the question of the integrity and fairness of Mr. Avery's trial hangs like a dark cloud over the Wisconsin judicial system. Amen. Pass the butter. Let's eat. Damn, that's good. Okay. Whew. Brilliant. Okay. You guys, I'm sorry. I'm just in awe. That's what I've been wanting to hear in this case for so long. Okay, here we go. Sorry, my excitement kind of overflows. This case presents special and important reasons justifying Supreme Court review. Number 1, Issue 1, ineffective assistance of counsel. The first issue concerns whether the Court of Appeals erroneously exercised its discretion when it applied a standard, contrary to this court's decision in State v. Allen in 2004, and contrary to this court's interpretation of Strickland v. Washington by requiring Mr. Avery to conclusively prove in his pleading without an evidentiary hearing that his allegations would have acquitted him. The Court of Appeals failed to analyze the cumulative effect of trial counsel's errors. This court should review this misapplication of the Strickland standard to the ineffective assistance of counsel claim pursuant to Wisconsin Statute 809.62. Number 2. Issue 2, Brady. The Brady issue concerns the Court of Appeals, finding that defense counsel has a burden of diligence to replicate from raw data the state's exact findings. Contrary to this court's decision in State v. Wierski and Supreme Court jurisprudence. This issue also concerns whether Wierski compels this court to find that the failure to disclose a police report allegedly truth train coming through containing favorable forensic evidence for the defense violates Brady truth train. Even if the defense could have hired an expert to do its own analysis, the issue further concerns whether the Court of Appeals erred by failing to consider the cumulative effect of errors in assessing Mr. Avery's claim, in violation of Kiles v. Whitley. This court should grant review because of the Court of Appeals' decision is in conflict with this court's decision in Wierski and the Supreme Court in Kiles. Oh, I'm loving this, you guys. Number 3, Issue 3, destruction of bone fragments. Deep breath. I'm ready. This issue concerns whether a state actor's destruction of contested evidence in violation of Wisconsin Statute 968.205 is sufficient evidence of bad faith to require an evidentiary hearing on a defendant's Youngblood versus Arizona claim that the destruction of evidence violated his right to due process of law. Statement of the facts in the case. On March 18th, 2007, many moons ago, Mr. Avery was convicted of his first-degree intentional homicide and a felon in possession of a firearm. He was found not guilty of mutilation of a corpse. He appealed. The Court of Appeals affirmed. In 2009, he filed a 974.02 motion requesting a new trial on January 25, 2010, after an evidentiary hearing. Mr. Avery's motion was denied, and he appealed. The Court of Appeals affirmed. In 2013, Mr. Avery filed a Pro Se 974.06 motion requesting a new trial, which was denied. On June 7, 2017, Mr. Avery filed a second 974.06 motion. The motion was dismissed without an evidentiary hearing. On October 6, 2017, Mr. Avery filed a 974.06 motion to vacate, and on October 23, 2017, he filed a motion for reconsideration. The Circuit Court denied his motions to vacate and for reconsideration. Okay, so audio is choppy. Okay, you guys, just so you know, it is YouTube, so there's not a lot I can do about it. I'm doing my best. I hope that it gets better. I'll try to stay close to the mic. On October 11, 2019, Mr. Avery appealed. He filed motions to stay and remand concerning 2 additional claims. He raised his claims in his motions to the Circuit Court of Supplemental Post-Conviction Motions. His Circuit Court denied his motion of supplement. In April of 2021, after a new witness revealed exculpatory information, he filed a motion of the Court of Appeals to stay his appeal and remand. Thank you, Julie. Thank you, Michael. Thank you, guys. So we have good communication. Good. On July 28, 2021, the Court of Appeals issued a per curiam opinion upholding the Circuit Court's summary denial of Mr. Avery's claims raised in his 974.06 motion and 2 supplemental motions holding Avery's 974.06 motions are insufficient on their face to entitle him to a hearing, but reserved Mr. Avery's ability to file a successive 974.06 motion on his claims in his motion to reconsider and 2 supplements, and his claim in his most recent filing. With the exception of the unreasonable determination of the facts discussed herein on pages 12 through 13, 29 through 30, Mr. Avery will accept the facts as stated in the Court of Appeals opinion on pages 2, 3, and 4. Argument number 1. Whether the Court of Appeals' imposition of a pleading standard requiring Mr. Avery to prove, on the face of his 974.06 motion, that each allegation will result in an acquittal conflicts with the controlling opinions of the Supreme Court, this Court, and other Wisconsin Court of Appeals decisions. A. Standard of review. This Court reviews the Circuit Court's discretionary decisions under the differential big words. Tired. This Court reviews the Circuit Court's discretionary decisions under the differential erroneous exercise of discretion standard, Allen 2004. Whether a defendant was denied effective assistance of counsel is a mixed question of fact and law, State versus Thiel. B. Impossible standard to meet. The Court of Appeals procedurally barred many of Mr. Avery's ineffective assistance allegations, concluding that Mr. Avery could have raised them in his 2013 pro se post-conviction petition. The only sufficient reason that the Court of Appeals accepted for Mr. Avery failing to raise 7 of his ineffective assistance equals claims previously was that unique circumstances existed wherein a pro se defendant is unable to perform or pay for an investigation, but later gains the resources to uncover new material facts and develop alternative theories of the crime. Finding this reason to be, quote, sufficient, the Court of Appeals parsed out 7 of Mr. Avery's forensic expert opinions and reviewed each opinion as if it was a separate claim of its own. The Court of Appeals inexplicably concluded that Mr. Avery could have conducted experiments in his prison cell in Boscobel, 250 miles from the Avery salvage yard. Mr. Avery had no more ability to conduct simple experiments than he did to hire nationally renowned experts. All of the allegations in his second motion have been included in the court's reasoning that Escalona, Navarra was not a bar. This court should address this issue because of the large number of indigent prisoners, including Mr. Avery, whose diligent efforts to access resources are thwarted. The fact that later an attorney is willing to devote hours of their time and resources because of their belief in their client's innocence should not be held against the prisoner when they later discover support for their ineffective assistance claim. Further, by parsing each of Mr. Avery's forensic expert opinions into separate, quote, claims and analyzing each individual opinion as if it were a motion of its own, the Court of Appeals misapplied the standard for an evidentiary hearing and failed to consider the cumulative effect of all Mr. Avery's forensic opinions. A movant's allegations and supporting material facts should be considered as one ineffective assistance of counsel claim, not transformed into individual ineffective assistant claims. Wow, this is beautiful. This court should determine whether the Court of Appeals misapplied the legal standard of what a movant must allege for an evidentiary hearing and unreasonably determined facts and misstated facts in the record in denying review. The circuit court must hold a hearing when the defendant has made a legally sufficient post-conviction motion and has the discretion to grant or deny an evidentiary hearing, even when the post-conviction motion is legally insufficient. Mr. Avery has alleged sufficient facts to demonstrate that his trial counsel's performance fell below an object standard of reasonableness when he alleged that counsel was ineffective for failing to hire experts, failing to investigate and impeach Bobby Dassey and the state's primary witness, failing to establish third-party suspects, and failing in numerous other ways, including similar failures of prior post-conviction failure. Wisconsin cases have found ineffective assistance for failure to hire experts. See State versus Zimmerman. The Court of Appeal erroneously applied Weatherall versus State 73 Wisconsin 2D, citing, quote, "Our court has called this hindsight is better than foresight approach to be," quote, again, Monday morning quarterbacking. Failure to consult with experts was not trial strategy. It was complete, I got to stop and look at this word, abdication of trial counsel's duty to at least attempt to rebuke the most damaging forensic evidence in the case. See State versus Hicks, which failure to obtain DNA analysis was not strategic decision when defense counsel knew that the root tissue of hair specimens could not be subject to DNA testing and did not pursue such testing. Another example, I'm guessing, is what they're doing these parentheses for, is failure to investigate thoroughly result from inattention, not reasoned strategic judgment. Current post-conviction counsel has demonstrated, among other things, that the blood in the RAV4 did not come from an EDTA tube, as trial counsel claimed, nor did it come from Mr. Avery's active bleeding finger, as the state claimed. In Mr. Avery's motion, his new experts collectively rebuked the state's theory about each piece of forensic evidence. Mr. Avery has sufficiently pled that counsel was ineffective. In Allen, this court provided numerous examples of motions not sufficiently pled, stating, quote, "There is a clear theme running through these and other similar cases." Allen. In all these cases, the motion presented no material facts, was repellent with bare bones allegations, or was replete with bare bones allegations, and was only based on the movant's own subjective opinion. Mr. Avery's motion stands in stark contrast. While the Court of Appeals paid lip service to this court's Allen requirement, it failed to apply the Allen criteria to Mr. Avery's claim. Oh, Lord, have mercy. That was beautiful. Instead, it erroneously applied the ultimate burden of prevailing on a post-conviction motion, as though Mr. Avery had received an evidentiary hearing. It improperly weighed the evidence Mr. Avery's new experts would have used to rebut the state's case as a circuit court is tasked with, and then it ruled as if Mr. Avery had an evidentiary hearing and failed. the court unreasonably determined the facts pertaining to the blood, bullet, and bones that would have prevented it if it had a transcript to review of an evidentiary hearing. The Court of Appeals is certainly not qualified to act as an expert on scientific evidence. Mr. Avery would welcome the opportunity to have his experts' opinions rigorously cross-examined by the state. Their ability to withstand adversarially challenged would demonstrate the value of their findings to the jury. In finding that in order for a movement to be granted an evidentiary hearing, Mr. Avery's experts must prove Mr. Avery's defense unequivocally, and the Court of Appeals imposed a burden contrary to this court's holding in Allen. I need a drink, sorry. It's raining buckets. Think of rain as purification. This is beautiful. I could read this all night, though I am very tired. Here we go. It admitted that Mr. Avery's experts' conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial, but required that each expert rebut the state's entire case. After parsing Mr. Avery's forensic evidence into separate, quote, claims, the Court of Appeal improperly imposed a burden of demonstrating that each individual piece of evidence would result in acquittal. It even required Mr. Avery to show that 3 blood-stain experiments, each on their own, would have achieved an acquittal, as well as required that Mr. Avery's expert findings on the trace material on Halbach's subkey, and I just lost chat, so I don't know if you guys are here or not. Computer just went dark. Is it raining that hard? I don't know, you guys, if I'm streaming. And I hate to not read it if we are streaming. I don't know. I'm good on OBS. I'm sorry for all the technical difficulties. It's almost like people don't want us to read this. Come on. Let's see. Let's get back to live. I may have to redo this tomorrow in its entirety. Like chat, all of YouTube disappeared, so I have no clue. I'm just going to sit here and wait it out. It could be that I have that much of a storm. It's really coming down like buckets. Man, I have to read this. I will just start over and record it if I have to. What do we got here? It's showing that I am live. I just can't see you guys. Well, you know what? On with the show. If you guys can see me, that's great. Let's keep going. If you can't, then I will do this over for you guys, which I really hope you can. It even required Mr. Avery to show that 3 bloodstain experiments, each on their own, would have achieved an acquittal, as well as required that Mr. Avery's expert findings on the trace material on Halbach's subkey, the DNA quantity on the subkey, and hood latch, the FL bullet, the bones in Avery's burn pit, would have each resulted in an acquittal. The court required Mr. Avery's new experts to state in their findings the ultimate legal conclusion that Mr. Avery was framed, which is ironic considering that the trial court did not require each piece of the state's forensic evidence in of itself prove guilt beyond a reasonable doubt. The jury was presented with the cumulative effect of all the forensic evidence. Moreover, the Court of Appeals misapplied the burden established in Strickland v. Washington and concluded that Mr. Avery cannot meet this burden by misrepresenting the expert's results as demonstrating that he was framed. Absent additional facts or arguments, we cannot assume that such measured support for Avery's frame-up theory would have led to an acquittal. The Court of Appeals effectively imposed a standard completely contrary to any precedent or law that in order for Mr. Avery to have an evidentiary hearing, he would have had to prove ineffectiveness on the face of his motion without the opportunity to cross-examine trial counsel. Okay, you guys, I'm going to try to work on YouTube here to see if we're still rolling. What is going on with YouTube? Like, what is that? I get a giant black box. Lord. Talk about blackout, you guys. Ouch, I was sitting on my foot and it's asleep. Okay, you guys, should I end the live or not? I don't know. All I got is a black box. I'm only on page 11 out of what? Let's see what we got here. Mine's giving herself a bath. 31, conclusion. Holy crap, yeah. I'm going to close it down. All right, you guys, I lost YouTube. I am so sorry. I will do a pre-recorded version of this tomorrow. I need to get some sleep. I love you guys. I know it says I'm live, but I can't even see y'all. I can't see chat. I don't even know. And it's 10:42 and I'm exhausted. So I love you all to the moon and back. I apologize for the technical difficulties. It's either the storm or YouTube. I don't know. I've been hearing a lot of people saying YouTube's really been screwing up. So we will see. Now, can I stop a live? Because I have no YouTube. How's that work? Maybe you guys have to stay with me all night. I don't know. Love you guys. Bye.